So the other case I asked you to look at is Campbell v. Clinton, and this is a direct challenge to a president's action under the War Powers Act that is decided in the D.C. Circuit, not by the Supreme Court. So factual background, you have in 1999 the U.S. committing armed forces under NATO to deliver airstrikes, including using U.S. fighter jets and cruise missiles in a conflict in Yugoslavia. President Clinton makes a report to Congress about this activity, so notice that the report is not stated as being pursuant to the War Powers Resolution, but consistent with what I mentioned before, it says consistent with the War Powers Resolution. So it's this effort to try and suggest you're making a report, but you're not formally triggering the War Powers Resolution. So after the president makes this report, there's a vote in the House. Now, there's a number of conservative members of the House who feel that this commitment of military power in Yugoslavia is an overextension of U.S. military power abroad and are displeased with this use of military power. So the first thing that happens is there's a vote on a declaration of war, which I think if you see the result, undoubtedly this is a political move designed to kind of put something on the record that Congress is not prepared to declare war, and that gets voted down. There is then a resolution to specifically authorize the president's airstrikes, and that fails to pass. And you'll notice that it's the closest of possible margins by which it does not fail to pass. Then there is a resolution put forward to require the president to cease the operation. That also does not pass, and as you can see, it fails to pass by a relatively wide margin. Then there's a resolution to fund the operation, and that passes. So some interesting kind of political dynamics, somewhat ambiguous result of what the House, in fact, thinks about the NATO adventure in Yugoslavia. So the operation in Yugoslavia continues for 79 days, which of course goes beyond the 60-day period in the War Powers Resolution. Prior to the termination of the conflict, a group of 31 congressmen who opposed the action in Yugoslavia sue for a declaratory judgment, and they want a declaratory judgment that the president's actions violate the War Powers Resolution and also violate the constitutional separation of powers. So this is the case that goes up to the D.C. Circuit. So note, the case is filed before the hostilities cease, but in the interim, as the case is pending, the hostilities have ceased. So very interesting opinion, because you end up with a three-judge appellate panel, and there's a majority, but then there are also three separate concurrences. So the majority opinion is that the president's action did not violate the War Powers Resolution or the Constitution, primarily because Congress always remained free to adopt a resolution that would have required the president to end the operation. But Congress never adopted that kind of resolution. And effectively, the majority saw the case as individual congressmen who couldn't win politically in the legislative chamber, trying to get the courts to make the legislature do what they wanted. And the majority says that's not how it works, right? That you in the legislative chamber, you try to persuade, and if you don't, then you're on the losing side. So that way of setting it up, the majority says, avoids a constitutional issues. We don't even have to get there. Now, the concurrences are really interesting. So Judge Silberman says the claims are not justiciable because the courts can't even decide whether or not a particular military operation is an act of war that would invoke the powers and limitations of Congress and the president under the war powers in the Constitution. And he also says the courts can't determine whether a military action is the kind of trigger that would have to trigger reporting requirements under the War Powers Act. So Judge Silberman says courts just aren't competent to make those kinds of determinations. Now, Judge Randolph says, well, I want to be a little more technical about what the issue was with respect to standing. So he says the standing question, whether these individual legislators have standing, and he talks about a body of case law that I kind of cut out of the opinion. There's a lot of discussion, but basically what it says is this. No, an individual legislator can't come to the court and say, I lost in the legislature, I want you to overturn that result. That's just the way voting works. But a legislator could come to the court and say, my vote didn't even count. It was effectively nullified. And there are cases that involve, procedural defects or unlawful procedural maneuvers to prevent certain legislators from having a vote or having a voice. So if it were a nullification question, Randolph says we could hear it. But here he says it's not a nullification question. Every representative had an opportunity to be heard and to vote. And further, Randolph said the whole issue is moot, because even though the declaratory judgment action was brought before the hostilities ceased, the hostilities have since ceased. Now, again, there's a kind of body of case law that I cut out. You don't need to worry about it too much. But in this question of ripeness or mootness of a claim and a declaratory judgment action, you can't just go to court for an advisory opinion. You have to have an actual case or controversy. You can sometimes go to court for a declaratory judgment before the controversy kind of actually hits the fan, so to speak, so long as it's imminent. If the controversy ends and there's no further issue about a remedy, like a monetary remedy or something like that, then there's no more controversy and the case might be moot. If the controversy ends, but there's a good chance that the same controversy might flare up and repeat itself imminently, then it may not be moot. So here, Judge Randolph says, there is no possibility of repetition of this conflict. It's over. It was a very unique conflict. It's not going to, this same conflict isn't going to flare up again. If there's some other conflict and this similar issue arises, maybe it wouldn't be moot. Maybe there'd then be an issue to be decided by a court, but this conflict, it's done. All right, so then you have Judge Tatel, and Judge Tatel says, okay, I agree, there's no standing for the individual congressman. But if there had been standing, he says, the issue in fact would have been justiciable. Judge Tatel says courts regularly decide factual questions and interpretive questions under the Constitution and under statutes where the language of the Constitution or the language of the statute is vague. In fact, this is what courts do. And so Judge Tatel says we could have made determinations about whether this constituted war. We could have made determinations about whether these were the kinds of hostilities that would trigger the war powers resolution. But we're not going to do it here because the claim is not justiciable because the Congress people don't have individual standing. Now, how does this all relate to the subject matter of our course? And we'll talk about this more when we meet in person in class. But if these issues of the separation of powers and the war powers and the relation of Congress and the president and the reporting relationships are interpretively difficult and legally difficult in the kind of ordinary kinetic world where you have jet fighters and cruise missiles flying over Yugoslavia, how much more difficult is it in cyberspace? So, for example, we looked at the Stuxnet virus. I showed you a video that included discussion of the Stuxnet virus. And so let's assume that the U.S. was involved in that, as most experts think, and that was an operation conducted by U.S. military/intelligence agencies. Is that an act of hostilities which has to be reported to Congress? Is that an exercise of the executive's war power? What role does Congress have, if any, in the oversight of that? Let's take as another example what everyone assumes to be true, that since we are being regularly hacked and attacked by nation states such as China, that we're hacking back. One of the ways you can respond to a cyber attack is a hackback. And if you're good enough to figure out where that hack is coming from, you might send your own denial of service attack or other things back to try and disable the hackers who are hacking you. Is that something that triggers the war powers? Does it trigger the war powers resolution? Is it an exercise of the executive's war power? Is it something else? Take as another example the launching of preemptive offensive cyber operations, another thing which we are almost certainly presently engaged in, which is part of existing national defense military doctrine. So you've got some group of, let's say, organized crime group who is hacking and stealing trade secrets of major U.S. corporations. You have a nation state, again, like China, that's doing things like that. And we're identifying where they are, and we're putting devices, malware on their systems so that we can monitor what they're doing. Is that an act of war? Is that something that triggers the war powers resolution? Is there any role for the judiciary to oversee any of those kinds of decisions, and if so, when? I think the short answer, at least in my view, is that there probably needs to be some greater legislative and regulatory clarity about how this all operates, and at least some greater sense of reporting and accountability among the branches about how these kinds of things are happening or can happen. I'm not sure what exactly the right solution to that is, but that's the kind of thing that we'll talk about when we meet in person next week.